Welcome to Nasdaq Trade Talks. I'm Jill Malandrino, global markets reporter at Nasdaq. On Monday, June 15th, the Supreme Court ruled that LGBTQ employees are protected by the 1964 Civil Rights Act, barring discrimination in the workplace. The effects upon case law could be enormous, setting a precedent along with 2015's decision legalizing gay marriage. Joining me this afternoon to discuss the historic decision is Moe Vela. He is the president and CEO of the Vela Group. He's also the former senior advisor to Joe Biden on LGBTQ affairs. Mo also served as CFO and senior advisor on Hispanic affairs for Vice President Al Gore. Mo, it's great to have you with us. Welcome to Nasdaq Trade Talks.
Thank you, Jill. It's great to be with you.
And how is the Supreme Court decision, how is that going to affect workplaces across the country?
Well, I think, to be really honest, if you weren't discriminating before, it's not going to affect you at all, right? If you were creating and promoting and providing a workplace environment as an employer that treated everybody with dignity and equality, this won't faze you. But for those of you who unfortunately were haters and continued to discriminate and terminate the employment of people based on their sexual orientation or their gender identity, you no longer will be able to engage in that type of hateful behavior. So frankly, I think the vast majority of employers and employees are good people, and our workplaces are traditionally equality minded. But there is something very wonderful and motivating and exciting just psychologically to know that the Supreme Court has said that you cannot be fired for your sexual orientation or your gender identity. I think that's a huge message to send across the nation.
It certainly is, especially in 2020 when we are grappling with a number of issues that have come to the surface. Now, how is Title IX, how did that convince Gorsuch and Roberts to swing their votes? Typically, they don't vote in line with more liberal thinking, if you will.
Yes, and I think this was the surprise of this ruling, to be honest. Gorsuch, I think everyone's talking about him, but the fact that the Chief Justice also was in the majority on this opinion also to me says something very loud and clear. What I feel like it's saying to us is, number one, that there is still a semblance of independence in our judicial system. This has always been a very, very powerful and valuable American tradition. And I'm so happy to see that it still exists in light of the incredible political division and ideological fighting that we have across the nation. It is wonderful and refreshing to see. So to me, what they were saying was, look, they made it very clear. The opinion was very, very succinct and very concise. Let's talk about the example that they used. If you have a man who's attracted to a man that works for you, and you have a woman that's attracted to a man that works for you, both of these people are in your workforce. You fire the man because he's attracted to a man. They now realize that that is considered under the umbrella that's protected under the Civil Rights Act of sex. So basically, they're saying that sexual orientation and gender identity are subgroups of the general protected class of sex. And so it's very fascinating because what they're saying is, if you treated that woman differently than you treated the man, they were both attracted to the same gender. And that right there would be then discrimination based on sex.
It seems like such an obvious distinction. And in 2020, we still have to come to terms with that. But why do you think the dissenting opinions think this is a legislative issue?
Well, because first of all, you got to remember that the long conservative justices versus the more progressive or open-minded justices, as I call them, the long-standing feud between all of them historically has been textualism, right, versus interpretation of the law, right? And so this is another reason this has become such a dramatic discussion in the last 24 hours or 36 hours, because you've got Gorsuch and Roberts saying, pretty much saying it didn't matter what they intended, okay? And they're still relying on the textualism, which was a Scalia tactic. But they still came to the conclusion that even if you look at it from a textual perspective and not an interpretive perspective, or try to interpret and apply it to today's standards, they still came to the same result and conclusion. And so to me, that makes this ruling that much more powerful, because no matter whether you're a textual person or an interpretive justice, the majority, 6 of them, came to the same conclusion.
Yeah, and Mo, it also happened in June for Global Pride Month, which is exactly what we needed right now. Thank you so much for joining us on Trade Talks.
It's my pleasure. Anytime, Jill.
Okay, thanks for joining me. I'm Jill Malandrino, Global Markets Reporter at Nasdaq.